The other thing that we've learned is that when people win licenses, not only are they winning licenses to operate medical marijuana facilities, they're also winning a free ticket to be sued because they will get roped into litigation from unsuccessful applicants that make all kinds of claims about program-wide fraud and inadequate scoring, and gosh, how could these people have gotten a license when my group is so good and I'm better than them, so I need to sue them, I need to sue the state, we need to start over from the very beginning. Those lawsuits will come, and you need to prepare your clients that the attorney's fees don't stop after you submit that application, and they need to be thinking about what's their appetite and what's their pain level for litigation after they win a license, because they should be thinking about those things so that they're prepared to address them. Their investors know that they may be asked to throw a little more money in the pot to defend against claims to protect the license that they just won. Also used to be a big concern about forum selection. And by that I mean, do you want to sue in federal court or do you want to stay in state court? The fear was always that cannabis companies would get booted straight out of federal court because the federal judge would say, it's illegal under federal law, this is a federal court, I'm not going to do anything about your case. That has not proven to be true. Federal courts, as everybody here knows, they apply state law, generally speaking, and federal courts, especially out west where there's been a lot more litigation, the markets have been around a little bit longer, they've been perfectly comfortable to apply state law in federal court, even though marijuana remains illegal under federal law. The biggest concern in the cannabis space right now as it relates to litigation are civil RICO claims, because these are claims that are based in violation of some type of law. In this case, it would be violations of the Controlled Substances Act, and how far can you go up that supply chain? If there's a problem at a dispensary, can you bring a RICO claim against the processor, against the cultivator, against the operation more generally? Those claims are getting a little bit of traction out west. So you need to be very careful as you're advising your clients how to structure their business, how to structure the transactions they have with their business partners in the space. When you have those agreements, make sure that you have indemnification and duty to defend provisions in those agreements so that if you are looped into a RICO claim by virtue of the fact that one of your partners is doing something they're not supposed to, that your client can be protected. And it's not on here, but also think about liability insurance for your cannabis clients. There are, and we've seen this again out west, a number of times where a cannabis company will get sued. They'll think they have coverage under their policy, and it turns out there's an exclusion. For either cannabis-specific exclusions or, again, violations of Controlled Substances Act. There was a case out of Colorado where a dispensary was sued after it sold an edible to a guy. He went home, he took it, had some type of psychotic break, and killed his wife. And his wife's estate sued the dispensary under the theory that it sold him a bad batch of edibles. And soon after the dispensary got sued, the insurer filed a deck action that there was no coverage under the policy. And there were two problems. Number one, the policy at issue was just a straight CGL policy. It was not a products liability policy, so there were exclusions for any claims based on products after it left the policyholder, which if you're a retailer, is a really bad policy to have in the context of a products claim, because your whole business is getting products and giving them away to other people for money. So you want to make sure that your clients are covered on that front. But there was also a cannabis-specific exclusion in that policy. And again, if you're a retail marijuana dispensary, that cannabis exclusion is a real big problem, because then there's basically no chance you're going to have coverage. There's some litigation about illusory insurance contracts. There was a case out of, I think it was Denver as well, it was a 10th Circuit case where there was a DEC action and the insurer made similar arguments, but I think they were couched more in the terms of public policy. The insurance contract itself is not enforceable. We're not relying on an exclusion. We're saying the insurance contract is not enforceable because the client's engaging in violations of federal law. And the court basically told the insurer, you knew what this company was doing when you wrote them the policy. It's not fair for you now to turn around and say, after you've accepted premiums from this policyholder, that you're not going to defend and provide coverage. So just keep a close eye out for the insurance policies that your clients are signing. And again, just generally, with Canada now legalizing marijuana for recreational purposes, there's going to be this brand new conflict that's introduced to the equation. We're not only dealing with state and federal conflicts, but international conflicts. There have been some border agents, for example, for the United States that have said, if you're an investor in a Canadian cannabis company and you're a Canadian citizen, we reserve the right to deny you entry into the United States. They've backed off a little bit and are now saying that as long as you're not traveling to the United States for purposes of marijuana, we'll let you in. But initially the blowback, and people were very concerned as Canadian companies now have access to real capital, they have access to markets, public markets there in Canada. They're going to start buying United States cannabis companies. And their operations team is going to want to travel in to the United States to find out how their new partner, how their new investment is doing. And there's going to be an issue there at the border because of the conflict between the United States and Canadian law. Yeah. There's not. Ohio, so residency requirements, when the market was moving into more of a regulated market in other states, residency requirements were pretty typical. They typically had a duration limit. I think in Colorado it was 2 years. You couldn't invest or own a Colorado cannabis company unless you were, a Colorado resident. But you put enough creative lawyers in a room and you find all kinds of ways to get around that residency requirement, right? I'm going to buy the real estate, I'm going to lease it to you at a percentage of revenue that would just so happen to be a 10% stake in your business, right? And in Ohio, that was a hotly debated topic when House Bill 523 was first being debated in the legislature, and then also when it went to the administrative agencies to make the rules for the industry. And the state basically said, this is a brand new industry. We want people who know what they're doing. So we are not going to put in a residency requirement under state law. That was part of the application process. To what extent are you going to hire people from Ohio? Tell us about your team and where you're all located. But there was not an outright prohibition on out-of-state investors or companies competing and operating in Ohio's market. Talk a little bit about employer rights. This is a question we get a lot at Frantz Ward. We have a large employment practice, and so we talk with our clients a lot about how this medical marijuana law affects employers in Ohio. And the short answer is it basically doesn't. Ohio employers still retain ultimate flexibility to permit or refuse to permit an employee's possession, use, distribution of medical marijuana. They can refuse to hire you, they can discharge you, they can discipline you, or take any other adverse employment action because of your use of medical marijuana. So you test positive at work for cannabis, you're not protected under Ohio law to keep your job or not be disciplined. And it doesn't interfere really at all with any federal restrictions on employment. There was a recent case out of Connecticut. It was a federal court issued a decision where an employee was using medical marijuana, applied for a job at a new employer, had a job offer, and then took a mandatory drug screen and tested positive for cannabis, and the employer refused to hire that person. Under Connecticut law, there are protections for patients where they can't be disciplined, et cetera, for being a medical marijuana patient unless there's some federal element that prohibited the employer from continuing to hire or employ that person. So the employee, or the applicant rather, the job applicant who had her offer rescinded, filed a lawsuit, and the employer argued, look, we are a federal contractor, and because of the Federal Drug-Free Workplace Act, we are required to enact policies to maintain a drug-free workplace, and one of those policies is that we drug test job applicants. So under Connecticut's law, we are permitted to refuse to hire this person. And the federal judge said, not so fast. There's no actual requirement under the Drug-Free Workplace Act to drug test people. That act is not itself explicitly required by federal law. So so the employee has a case and won on summary judgment. Now that case is going to proceed to a trial on damages. That's not the case here in Ohio. Ohio law does not contain protections for employees who use medical marijuana, with one exception, and that's in the context of unemployment compensation. If an employee is fired for using medical marijuana without the employer having some type of written policy that the employee has notice of, that employee can get unemployment compensation benefits. But if there is a written policy that the employee has notice of, then the employee is not eligible for unemployment compensation for being a medical marijuana patient. For workers' compensation, again, nothing really changes. Intoxication still remains a defense to a claim for workers' comp benefit, and they can't currently obtain reimbursement for medical marijuana expenses, largely because medical marijuana is, number one, it's not prescribed, it's only recommended, and it remains illegal under federal law. Now, there are some considerations that we do talk with our employer clients about. There's this idea that you can enact a written policy as it relates to medical marijuana. As an employer, you want to be really careful talking with your employees about their health and about whatever health issues they might have, because you still have obligations under the Americans with Disabilities Act and under the Family Medical Leave Act. And should an employee come to you and say, I was just diagnosed with multiple sclerosis, and I have a medical marijuana recommendation, I'm going to be using medical marijuana to treat my condition, and they fail a drug test, and you fire them, you're probably going to get sued for some type of discrimination claim, right? Or they come to you and say, I have MS, I need a reasonable accommodation. I need you to allow me to use medical marijuana. And you say, no, I'm not giving you a reasonable accommodation because I'm not required to, because it's still illegal under federal law. And because you're using medical marijuana, I'm going to fire you. I would expect a retaliation claim at that point, especially if you do not have a written policy that is fairly applied among everybody in your company that prohibits the use of medical marijuana. So if a client's going to take adverse action against an employee for using medical marijuana, it needs to be very clear as to why that action is being taken. It's explicitly for failing a drug test, right, in violation of our company's policy on the use of controlled substances, including medical marijuana. The more you get into these sort of ad hoc person-by-person determinations as it relates to medical marijuana and health issues generally, the company is putting itself at a lot of risk. The future of the cannabis industry, for folks who like it, is very bright. If you're not thrilled about the liberalization of cannabis policy, it can be a very scary place. Canada taking the action to legalize recreational marijuana is going to push the international community even further than it's been so far. More and more states are moving from medical-only programs to adult use programs. Michigan, for example, has an adult use ballot initiative that's up this November. Most folks I talk to expect it to pass. Michigan has actually had a medical program since 2008. It has not been very well regulated, but they've had a program. It would not surprise me to see Michigan then being the catalyst among the Midwestern states. You're going to see probably Illinois, probably Ohio in a couple of years, maybe Pennsylvania, Indiana, Wisconsin, all now have adult use ballot initiatives that will have a larger percentage of support than they might otherwise have had, because now it's happening in our own backyard. But we still have these uncertainties as it relates to federal law. Talked about the Food, Drug, and Cosmetic Act, and how does that jive with industrial hemp and state legal programs, CBD and Epidiolex. Talked about what the FDA will do and the FDA's position on using CBD. It's not really clear what the makers of Epidiolex are going to do when its competitors are out in the market marketing, over-the-counter CBD dietary supplements that they want to sell to patients, through prescriptions, and they're charging like 30 grand a pop for those prescriptions. A lot more lucrative for them to have a corner on that market. How does the liberalization of cannabis policy affect international treaty obligations? The only reason that CBD itself is even still scheduled under federal law is because the FDA and the DEA think it's required by virtue of international treaties. There's a comment period that closes, I think, next week to make recommendations to the World Health Organization as to whether or not CBD should actually be a controlled substance in the first place under international treaties. And so far, a lot of the movement at WHO and the UN is a recognition that there's not a ton of risk as it relates to CBD. So we may see next year CBD pulled entirely from the Controlled Substances Act anyway. And one of the most important things that advocates are very concerned about is what do we do as we legalize cannabis throughout the country? What do we do about people that have cannabis-related convictions, especially for conduct that is now legal? You will see under a lot of new ballot initiatives an effort for automatic expungements, opportunities to vacate prior convictions, to release people from prison if they're incarcerated or in prison or in jail for conduct that would be legal under some type of new regime. That's a whole other public policy argument that advocates are having as we see cannabis policy changing throughout the country. I'm going to turn now to attorney ethics, but before I do, does anybody have any questions about the business sides of things before we talk specifically? Yes, sir. Sure. So border crossings for Canadian citizens who are involved in Canada's cannabis industry can be dicey because United States border enforcement officials have said if you are, because it's illegal here in the United States, if you are an investor or a business owner in Canada and you're coming to the United States to do something related to cannabis, you will be deemed inadmissible. They're not going to let you into the country. They'll ask you. Yeah, they're going to ask people at the border if they suspect that they're involved in some way in the cannabis industry. Your car comes through and it smells like pot. You're going to get asked, right? And they're going to be on high alert now because there's going to be one of the biggest criticisms of sort of patchwork versions of cannabis policy is people buying product legally in Colorado and taking it to Nebraska, where it's illegal. So this sort of cross-border, there was just a guy in Mississippi. He bought 2 pounds of cannabis at a state out west and drove down to Mississippi, where it's very illegal. And he got, I think, 9 years in prison on a drug trafficking charge. So I would expect border agents at the Canadian border to be on hyper alert for people coming from Canada bringing product they purchased legally there into the United States because they're going to be concerned that it's now just easier to traffic across that border, right? You can carry it around all you want in Canada, but you can't, and they're going to want to bring it across the border, as sort of a matter of course. So I would expect them to ask people more about cannabis at the border, and it's illegal to lie to a border agent. So when they ask you, by law, you're required to be truthful. So we'll have to see how that sort of fleshes out.